Attorney Getz entered a notice of appearance 3 days ago and requested to appear by reliable electronic means, not for today's hearing, but rather...
It was for today's hearing, Your Honor. It indicated it was for a bond hearing.
Well, she wasn't picked up until today.
I understand, Your Honor, but we applied in advance with the understanding that she would be turned in. And I am here and I have been here since 1 o'clock. Well, I've been here since before 1. I left Bismarck at 11 a.m. and I'm devoting at least 3.5 hours to this matter today because I was not allowed to appear in REM, Your Honor. I did receive a call 20 minutes.
Stop.
20.
So I understand that you've been here, but I was just informed of this hearing that Ms. Holmquist was taken into custody at approximately 12:10 p.m.
Yep.
The court accommodated this hearing at 1 o'clock on an emergency basis for DM47. This is a Stutzman County matter. Ms. Holmquist appears in reliable electronic means from the Stutzman County Correctional Center. Ms. Getz, her attorney, appears in person in the Stutzman County courtroom, courtroom number 1. The door appears to be propped open. The building is open. We're live streaming today's event. This is an open and public hearing. Due to the court's other business, I'm in Barnes County, in the Barnes County's courtroom. Doors unlocked and opened here as well. Mr. Stegman does not appear in person by counsel or otherwise. Procedurally in this case, after a trial on this divorce action and parenting responsibility action, where both parties appeared unrepresented and tried the case, the court issued its judgment on January 9, 2025. Thereafter, there were matters that have not been made part of this record directly, involving requests for contempt and requests for protection or restraining orders in various cases. The court has ruled on those requests before. Most recently, there was a motion for order to show cause of contempt filed by Mr. Stegman on August 27, 2025. This is record index 105. I should note for the record, the state of North Dakota is also a statutory party of interest in this matter. And Ms. Shar has indicated that she is not appearing on these matters as they are unrelated to child support. Mr. Stegman filed a motion for order to show cause of contempt. The court issued an order to show cause. That order to show cause was issued on September 16, 2025, record index 130. The court at that time had found prima facie evidence of contempt and scheduled a order to show cause hearing on October 1, 2025 in Stutzman County's courthouse. Notice of that hearing is in the record as 131. Those documents were served on Ms. Holmquist at her last known address by mail and by sheriff's service. Mr. Stegman was served at his last known address. Ms. Shar was served by electronic filing. The court held a hearing on October 1, 2025, at which time Ms. Holmquist appeared personally before the court. Mr. Stegman appeared personally before the court. Both at that time appeared unrepresented. The court informed Ms. Holmquist of her rights in contempt proceedings.
At the October 1st hearing, the judge made everything painfully clear. He warned Mom that jail was on the table. He explained her rights. He gave her choices: public defender, private attorney, or represent herself.
Court explained that it intended to consider jail as a potential consequence, and so it afforded Ms. Holmquist an opportunity for a public defender, or to represent herself, or to hire counsel. At that time, Ms. Holmquist indicated that she needed a continuance to hire an attorney. The court granted that continuance. The court asked Ms. Holmquist where the child was. In the interim, Ms. Holmquist explained that the child was at daycare. The court explained to Ms. Holmquist that if a continuance was granted, that she would need to immediately follow the court's prior judgment in terms of the parenting plan. The court informed Ms. Holmquist that if she failed to comply with that, there would be consequences. The parenting plan that is in place and effective right now afforded Ms. Holmquist parenting time on Wednesday night until 9 p.m. The court inquired of Ms. Holmquist if she understood the parenting plan and what was being required of her if the court granted a continuance. Ms. Holmquist indicated to the court at that time that she understood and agreed. The court then granted the continuance of the order to show cause, Record Index 140 and 141. The hearing was continued to August 15, 2025 at 9:30 a.m. On the record, the court had a discussion with Mr. Stegman and Ms. Holmquist about exchanges of the party's child. Mr. Stegman requested that the exchange occur as required by the judgment at the Stutzman County Courthouse as required. The court acknowledged that request, and it was put on the record that everyone understood where those exchanges were to occur. The day after the continued hearing, the court received another affidavit from Mr. Stegman indicating that Ms. Holmquist refused to exchange the child as required by the judgment on the evening of October 1, 2025 at 9 p.m. at the Stutzman County Courthouse. Thereafter, on the court's own accord, the court issued an order to show cause. And rather than issuing an order to show cause on a summons basis, the court issued a warrant of attachment, which is required or allowed by statute for Ms. Holmquist's arrest, so she could be brought before the court for today's hearing. That warrant of attachment was dated October 2, and it commanded that the Barnes County Sheriff and/or Stutzman County Sheriff's Office take Cassandra K. Holmquist into custody and hold her at the Stutzman County Correctional Center until she could be brought before this court. That's Record Index 147. There was a service document and a notice of entry of order, Record Index 148, indicating that the warrant of attachment and declaration of service were mailed to Ms. Holmquist and Mr. Stegman and served on the Barnes County Sheriff, Stutzman County Sheriff, and Attorney Shar on October 2. Attorney Getz entered a notice of appearance 3 days ago and requested to appear by reliable electronic means, not for today's hearing, but rather...
It was for today's hearing, Your Honor. It indicated it was for a bond hearing.
Well, she wasn't picked up until today.
I understand, Your Honor, but we applied in advance with the understanding that she would be turned in. And I am here and I have been here since 1 o'clock. Well, I've been here since before 1. I left Bismarck at 11 a.m. and I'm devoting at least 3.5 hours to this matter today because I was not allowed to appear in REM, Your Honor.
Mom is arrested on October 2nd. Fast forward to today, her attorney shows up irritated, inconvenienced, and clearly frustrated. She complains about travel time, scheduling, and lack of notice.
I did receive a call 20 minutes.
Stop.
20.
So I understand that you've been here, but I was just informed of this hearing that Ms. Holmquist was taken into custody at approximately 12:10 p.m.
Yep.
The court accommodated this hearing at 1 o'clock on an emergency basis. So while you and your client might have planned this, this was stuck on my calendar on an emergency basis.
Your Honor, if I may, we contacted the clerk.
So this wasn't a planned hearing. The court anticipated or expected your request for reliable appearance, electronic means appearance, to be for the October 15 hearing, and the court denied it on the basis that there was an outstanding warrant and your client hasn't been complying with the court's previous orders on multiple occasions, and I wanted her present and I wanted you present.
Okay.
So I understand that this is an inconvenience for you.
It is.
But you need to be reminded, Ms. Getz, that you're doing this on something that you've planned, and this is an emergency on the court's basis. So I stuck you in and fit this on my calendar at a time where it was not planned or expected.
Okay.
So
Coordinated
with
with the
that,
clerk's office.
there was no notice of hearing for today's hearing issued because this hearing was done on an emergency basis. Again, I was informed at 12:10 p.m. today, and it was stuck on my calendar at 1 o'clock at the court's earliest convenience. And so if it is inconvenient for you, it is because no notice of hearing was provided, because the court didn't know about this until right before the hearing. And I, as a courtesy, am seeing your client as soon as possible. Understood?
I understand, Judge.
Ms.
No.
Holmes, do you understand why we're here?
Yes, Your Honor.
Ms. Getz,
Yes, Your Honor.
go ahead.
Thank you. With regard to this matter, Your Honor, we are set for a full hearing next week. My client does have defenses that she intends to raise at that order to show cause hearing based on case law in the North Dakota Supreme Court based on best interests of the child and whether or not it is willful to not turn over a child when there is an investigation in child abuse and things of that nature. I am currently exploring and investigating those things, Your Honor, given that I was just given this case. I do believe that she has defenses, Your Honor, and we do intend to fully lay them out next week. We are asking for that opportunity as opposed to her being jammed up here again. We've known that this is going on. Obviously, I'm new to the case, Your Honor, but we do fully intend to litigate this matter next week and fully explain ourselves to the court. And we are asking for that opportunity, and we are asking that she be released on her own recognizance, since she did in fact contact counsel and hire them as she indicated to do, and that was the purpose of her continuance. And while I understand the court had very specific instructions with regard to the child, that also orders, a remedy in this situation or a correction or a repair in this situation when there has not been a contempt finding, Your Honor. She has not been afforded due process. She has not had a full hearing on the matter, and we are asking that the court delay judgment and delay any sort of imposition that could prejudice her while we prepare for this hearing next week. So we are asking that she be released on her own recognizance and allowed a full opportunity for hearing next week on the 15th.
It's conditional freedom. She must immediately comply with the parenting plan through the sheriff's office. No delays, no interpretations, no excuses. If she fails, she goes right back into custody.
Has your client turned over the child?
She has not, Your Honor, but again, we have defenses under case law that I believe the court should fully hear before making a determination as to whether or not her freedom is impinged.
Yeah, so the court finds that there is prima facie evidence that there is continuing contempt. The court, again, has issued a warrant of attachment. I'm going to allow you to make an argument. You've made an argument for personal recognizance. Ms. Holmquist, is there anything that you want to tell me before I make a decision?
Not at this time, Your Honor.
The court is going to issue a bail order. The respondent can be released and discharged upon the following conditions. The respondent will be released on her personal recognizance on the signing of a promise to appear and further conditions that the respondent will, through the sheriff's office, immediately follow the parenting plan set forth in this court's judgment. If she does not follow through with the judgment immediately, she will be back in custody immediately. The court will give her a full opportunity to present her defenses and a full opportunity to present evidence at the previously scheduled order to show cause hearing. But at this time, that is the court's requirement. Personal recognizance, promise to appear, conditioned upon the defendant or the respondent fully and strictly complying with the court's previously entered judgment. Am I clear, Ms. Getz?
Indeed, you are, Your Honor.
Ms. Holmquist, do you understand what I've just ordered?
Yes, Your Honor.
And are you intending to comply with the court's order?
Yes, Your Honor.
And do you understand there will be consequences if you do not?
Yes, Your Honor.
All right, with that, we're adjourned.
This case isn't about paperwork or inconvenience. It's about accountability. I'll be watching the October 15th hearing closely because that's where everything comes to a head. Thanks for watching, Rebel Chaser family. I'll see you on the next one.